Welcome, and thank you for checking out this video presentation. My name is Maria Wanchek, and I was born and raised in North Dakota. Since January of 2013, I've spent a lot of time studying not only the history of abortion, but also the recent legislation passed in North Dakota, including Measure 1. For me personally, I won't actively promote a policy that I don't fully understand. After my research, I now know that not only is Measure 1 good legislation, but it is one of the most important votes in the history of our great state. Hopefully, after the presentation, you too will understand why I believe this. I encourage you to share this presentation with everyone, as long as it's not altered. Thank you. Measure 1 states, the inalienable right to life of every human being at any stage of development must be recognized and protected. There are 5 key components that make up the story leading up to Measure 1. The first is a quick glance back in time looking at the history of abortion and how it affected the states. Second, we'll see how the state of North Dakota reacted to the Roe v. Wade ruling. Third, we'll look at the 3 major abortion proponents: the National Association for the Repeal of Abortion Laws, Planned Parenthood, and the Center for Reproductive Rights, and take a look at their strategies. Fourth, we'll meet some judges and look at how the courts are handling abortion regulations. Fifth, we will focus on the debate over Measure 1. Let's start with history. By the year 1900, every state had strict anti-abortion laws in place. On November 7, 1972, North Dakotans voted on Measure 1, which would have legalized abortion in our state. The initiated ballot failed, with 77% voting against the measure. This important vote showed that the people of North Dakota were not in favor of abortion. Only 3 months after North Dakotans voted to keep abortion illegal, the Roe v. Wade court ruling was released on January 22, 1973. This ruling made abortion on demand through all 9 months of pregnancy the new and official law of the land, and completely disentitled the states to have very little say on a highly polarizing, moral, and ethical issue. The map shows the states which had total bans on abortion, and those that had recently begun to loosen their abortion laws to allow for a variation of the rape, incest, and life of the mother exceptions. Altogether, this accounts for 46 out of the 50 states. Supreme Court Justices William Rehnquist and Byron White disagreed with the ruling. In his dissenting opinion, Justice White summarized the injustice to the states. I find nothing in the language or history of the Constitution to support the court's judgment. The court simply fashions and announces a new constitutional right for pregnant women, and, with scarcely any reason or authority for its action, invests that right with sufficient substance to override most existing state abortion statutes. Over the ensuing years, states began to fight back. In just the last 3 years, there has been more abortion regulations enacted by the states than in the entire previous decade. Between 2001 and 2010, there were 189 enacted laws, and between 2011 and 2013, there have been 394 enacted laws. How did North Dakota react to Roe v. Wade? North Dakotans, through their elected representatives, have established a wide array of common-sense abortion regulations. Not only are these regulations in place to reduce abortions, but to protect the safety of women and minors, as well as infants born alive. Let's take a look at some of them. We have an informed consent law. This means that the woman seeking the abortion must be verbally told that the abortion will terminate the life of a whole, separate, unique, living human being. There is a parental consent law for minor girls and a ban on abortion past viability, when the baby can survive outside the womb. Notices must be posted in abortion facilities which state, "No one can force you to have an abortion. It is against the law for a spouse, a boyfriend, a parent, a friend, a medical care provider, or any other person to in any way force you to have an abortion. A recent law against off-label use of abortion-inducing drugs is currently in litigation. An ultrasound must be offered at least 24 hours prior to an abortion. Abortion is prohibited for sex selection or based on genetic abnormality. The heartbeat bill, which banned abortions after detectable heartbeat, is currently in litigation. There are laws requiring record keeping and reporting. Partial birth abortion is banned in North Dakota. And we have restrictions against using public funds for abortions. These regulations are at the core of why Measure 1 is so important, but we'll get back to that in a few minutes. Before we move on to the out-of-state groups, there are a few definitions important to understand. A fundamental right is a right deemed to have the highest degree of legal protection according to the Supreme Court of the United States. I think it's important to know that these rights are not bestowed to us by our government, but are rather considered God-given or inalienable due to natural law. Strict scrutiny. The court automatically presumes the policy to be invalid unless the government can demonstrate a compelling interest to justify the policy. In other words, the abortion regulation is scrutinized in the strictest way possible. After a state passes the abortion regulation and it ends up in going to court, the judge will automatically consider the regulation unconstitutional from the get-go unless the state can prove its interests are more compelling than that of pregnant women seeking abortions. Using an analogy, it is like the regulation is being considered guilty until proven innocent. Undue burden test. The legislature cannot make a law that is too burdensome or restrictive of one's fundamental rights. In other words, the abortion regulation cannot be viewed as too much of a burden to women seeking abortions, or it will automatically be thrown out by the court. The strict scrutiny and undue burden test are an essential part of protecting our most fundamental liberties, such as the freedom of religion, thought, and peaceable assembly. But in the hands of activist judges and radical pro-abortion groups, these legal defenses can also be severely misused. Let's take an in-depth look at the pro-abortion groups, all of which exist and operate out of state. The NARAL, or the National Association for the Repeal of Abortion Laws, was an organization created before Roe v. Wade, whose main goal was and is to remove state laws against abortion on demand. Planned Parenthood is the biggest abortion provider in the U.S., with a net worth over $1 billion, and the Center for Reproductive Rights is similar to the NARAL in that they actively lobby and litigate on behalf of abortion providers across the country. It is important to note that all three of these groups advocate for abortion on demand through all 9 months of pregnancy for any reason at all. It is their mission to ensure easy surgical and pharmaceutical abortion access for all women and teenage girls here and abroad. They even set quotas for abortions for their affiliated clinics. Like all smart organizations and businesses, they are constantly creating and implementing strategic plans for the future. With billions in government aid and millions pouring in from abortion profit, groups such as Planned Parenthood have the vast resources necessary to carry out their objectives. One evident obstacle to their plan is an increasingly conservative Supreme Court. The Center for Reproductive Rights features this article on their website, What If Roe Fell? They view the reversal of the Roe decision as a severe threat. According to their own research, they find that 30 states are poised and ready with bans in waiting, set to be enforced the moment Roe is overturned. An article in the NARAL website asked the same question. Could the government really outlaw abortion if the U.S. Supreme Court overturned Roe v. Wade? Yes is the answer, with a list of which states and which type of bans would occur. Another study done at City University of New York and Yale University also came to the same conclusion. The study admits the Supreme Court is but one vote away from overturning Roe. A map from the study shows which states are most likely to immediately ban abortion. To ensure that abortion on demand would be secure in the states after the reversal of Roe, Planned Parenthood and the Center for Reproductive Rights created a winning strategy for the states. On their website, the Center for Reproductive Rights has a section entitled Using State Constitutions to Protect Reproductive Rights. They admit that state constitutional challenges can provide an effective strategy for defending and expanding reproductive rights. At the bottom of the page, it says, this strategy may become even more important given the uncertainty over whether the U.S. Supreme Court will continue to weaken the protections afforded by the federal Constitution. Starting in the 1990s, pro-abortion groups were very successful with their state constitutional strategy. Step 1 of this strategy is to pick an abortion regulation in a particular state and then sue the state over that regulation. The judge will run the state's new abortion regulation through the strict scrutiny and undue burden test. The regulation will be thrown out as unconstitutional, and then comes the real kicker. The judge will then discover and declare abortion as one of those God-given fundamental rights within the Liberty Clause of the state's very own Constitution, therefore using the state's own Constitution against itself, practically straitjacketing it from enforcing any further regulations and securing the future of abortion in that state regardless of what happens with Roe v. Wade. After this, the pro-abortion groups rush in like wolves, have a heyday with litigation, and eventually, court case by court case, strip the state of enacted laws concerning abortion until there's nothing left. Women are left without safety precautions, parents are left without a say in their minor daughter's health and emotional well-being, and taxpayers end up funding abortion on demand. This has already occurred over and over in multiple states, and it has occurred right next door to us in Montana, as I'll show you in a moment. Using a state's Liberty Clause is actually a new twist on an old scheme. Before they used the Liberty Clauses, they only sued states which had an explicit right to privacy within their state constitutions. This means that the right of privacy is specifically mentioned in their state constitution's text. Much of the rationale behind the Roe v. Wade case was dependent upon the right to privacy, as if the right to privacy was a sort of blanket that covered immoral acts. The reasoning being that if an act is personal, private, and consented to, then it's acceptable. My goal is not to go into depth concerning the Roe v. Wade case, but to point out that Planned Parenthood's initial scheme was to get state judges to invent and declare abortion as fundamental under the state's explicit privacy clause. The reason they no longer use the privacy clause and have now turned to the more common liberty clause is because they ran out of states who have privacy clauses in their state constitutions. The first map shows the states that have an explicit right to privacy, and the second map shows how nearly all those states now have abortion listed as a God-given fundamental right. These are the states where common-sense abortion laws have been ravaged by Planned Parenthood and the Center for Reproductive Rights. I want to show you how this winning strategy plays out in the courts. Right next door in Montana, Planned Parenthood has been successful in removing most state laws regulating abortion, as well as enacting, by judicial activism, taxpayer-funded abortion. They accomplished this by contriving with certain judges to declare abortion as a fundamental right under the privacy clause of that state's constitution. It doesn't end with government-funded abortion, but continues down a slippery slope when groups like Dignity in Dying enter into the picture with a push for physician-assisted suicide. Let's take a look. In 1997, the Center for Reproductive Rights litigates to remove a Montana law requiring only licensed physicians to perform abortions. In 1999, a lone judge ruled the minor consent law unconstitutional and deemed abortion as a protected fundamental right under the Montana Privacy Clause. In 2008, a lone district court judge ruled physician-assisted suicide to be legal. In 2009, the Montana Supreme Court held that doctors could not be prosecuted for assisting patients to die. This was a decision imposed on the people based on the privacy clause in their state constitution. In 2012, Bill number 120, a referred measure requiring minors 16 and under to have parental consent to get an abortion, passed by a popular vote of 70%, but a judge barred the Attorney General from defending the new law. When judges begin to legislate from the bench on behalf of radical pro-abortion and pro-euthanasia groups, and the public's popular votes don't count any longer, that is court tyranny at its worst. Measure 1 would protect North Dakotans from judges creating new laws from the bench. So what was the result of all this judicial activism in Montana? As I mentioned before, it has been stripped of its abortion regulations, which mirrors those of North Dakota. Laws which require 24-hour waiting periods before an abortion, the informed consent law, and lastly, laws against taxpayer funding for abortion. This legal strategy has just begun here in our state. Unlike Montana, North Dakota does not have a privacy clause, but a judge here invented an absolute or fundamental right to abortion on demand under the Liberty Clause of our Constitution. In some ways, if Planned Parenthood is successful in defeating Measure 1, then North Dakota becomes a type of prize to them, because they know if they can use our Liberty Clause, then they can repeat the procedure across the U.S. In 2011, the North Dakota Legislature passed a new law regulating the use of abortion-inducing drugs. With the help of the Center for Reproductive Rights, Judge Wickham Corwin ruled in favor of the Red River Abortion Facility in Fargo that the law was unconstitutional and claimed abortion as a fundamental right protected by the Liberty Clause in the North Dakota State Constitution. At the same time, another law that required abortionists to have admitting privileges at a hospital in case of emergencies was blocked by the same judge. It may be too late for Montana to turn the tide, but in North Dakota we are not yet entrenched in a radical pro-abortion agenda yet. That is the purpose of Measure 1, to act as a protective shield, a sure defense against the onslaught of bullying by radical pro-abortion groups and agenda-driven judges. Next we'll focus on the last key component, which is Measure 1 itself. There are a few important definitions to understand. A living will is a document in which you say what medical decisions should be made if you become too sick or injured to make those decisions. A do not resuscitate order allows you to choose before an emergency occurs whether you want CPR. Advance directives. Describe your preferences for end-of-life care. Legislatively referred constitutional amendment. A proposed constitutional amendment that appears on a state's ballot as a ballot measure because the state legislature in that state voted to put it before the voters. Measure 1 is a legislatively referred constitutional amendment. It was passed by the House of Representatives by a 57-35 vote. With all the information floating around out there, how do you know what's right? One group claims that Measure 1 is bad for the state, was sloppily written with unintended consequences, and gives too much power to the government in what should be personal health decisions, while the other group maintains that Measure 1 is good for the state, was carefully written to avoid unintended consequences, and preserves the rights of the people to make their personal health care decisions. How do you know which group to trust? Well, you could trust neither of them and do the research on your own. You could trust well-known local leaders who either endorse or oppose the measure. You could trust the television ads, or you could just follow the money. There are two main committees that were created for and against Measure 1. North Dakota Choose Life and North Dakotans Against Measure 1. As of October 8th, the group North Dakotans Against Measure 1 have received most of their campaign funds from out-of-state interest groups. You would think these interest groups would be end-of-life advocates or elder care groups, but as of October 8th, 95% of North Dakotans against Measure 1's donations came from various Planned Parenthood groups from out of state. Where is North Dakota Choose Life's money coming from? 99.5% of their income is from here. If this issue is about end-of-life care, as North Dakotans against Measure 1 maintain, then why is all their money coming from Planned Parenthood? Truth is, Planned Parenthood doesn't care about end-of-life issues unless it is the unborn child's end that will bring them a profit. I believe that the opponents of Measure 1 are using the end-of-life arguments to scare people to vote no on Measure 1, and as a mask to the true issue of abortion on demand, because they know that abortion is not well accepted in our more traditional and conservative state. Regardless, we will examine a few of the most common claims against Measure 1 in the light of state law. Measure 1 could nullify living wills, do not resuscitate orders, and advance directives. The misunderstanding. Measure 1 says life must be protected, so if a doctor follows an advance directive to remove life-sustaining treatments or support, then they could be guilty of homicide. The truth. Allowing someone to die when death is already imminent is not physician-assisted suicide, which is illegal in North Dakota. Removing life-sustaining treatments or support in order for approaching death to take its natural course is not homicide. An example. Person A is in the hospital, and despite many setbacks, the doctors say there is still a small chance the person could survive. The patient, or the relatives of the patient, ask the doctor to give a lethal dose of drugs that will end the patient's life. In this scenario, the person is asking for assisted suicide, which is illegal in North Dakota. On the other hand, Person B is in the hospital and despite multiple efforts, treatments, and time, is continuing to decline, and doctors agree there is nothing else that can be done to bring this person back to better health. They discontinue treatment and prescribe pain medications to ease the patient's suffering. The pain medication, as a secondary side effect, quicken the patient's dying process to some degree, but this is not the purpose of the pain meds. Eventually, the person dies. This would not be assisted suicide, and nor would it be considered homicide under Measure 1. Measure 1 could ban in vitro fertilization. The misunderstanding. Measure 1 says life in all stages must be protected, so anything that destroys or kills an embryo or fetus will become illegal. The truth. In order for an IVF doctor to be prosecuted in our state, they would have to intentionally destroy an embryo. According to legislative records, Dr. Dahl, an IVF doctor in North Dakota, was asked by Senator Olofsson whether they destroy any embryos that may be viable. The records reflect that Dahl responded no. According to Dr. Christensen, another IVF doctor in North Dakota who testified before the legislature, resulting embryos are either transferred into the uterus or cryopreserved for future attempts at pregnancy. An example. A personhood bill was proposed and failed in the 2009 North Dakota legislative session because it defined human life as any organism with the genome of Homo sapiens, and further required that this meaning of life be used for all constitutional and legal documents of the state, for purposes of interpretation of the Constitution and laws of North Dakota. In summary, Measure 1 is not as specific about when life occurs. The wording of Measure 1 is too broad and has too many unintended consequences. The misunderstanding. Measure 1 is so vague that it could be interpreted to mean anything. The truth. It is established North Dakota law that general or broad objectives cannot be self-executing, immediately go into effect, without further clarification by the legislature. An example. In 1984, a measure was approved by North Dakota voters for the right to bear arms to protect family, property, and self. This too could be viewed as an extremely vague amendment. One may even ask, does bear arms mean I can protect my front yard from looters with a semi-automatic weapon aimed in their direction? Obviously, the right to bear arms required further clarification from the legislature, but voters trusted their elected representatives and were not scared off by hypothetical situations. In summary, Measure 1 was written to be specific enough to protect pro-life laws within our state constitution, but broad enough to not specifically outlaw abortion. After all my research, I came to several conclusions. The Roe v. Wade decision of 1973 directly opposed the voice of North Dakotans who only 3 months earlier declared with one voice that abortion on demand was not in line with our morals and values. The Roe decision sparked a robust set of abortion restrictions and regulations in our state. Outside abortion groups continue to impose their radical agenda on the pro-life people of North Dakota. Mindful that the Roe v. Wade ruling could be reversed and left to the states to decide, abortion groups are proactively and systematically securing unlimited abortion rights within the frameworks of state constitutions. Due to the recent litigation and judicial activism in North Dakota courts, and responding to the will of the people, the state legislature and government actors are attempting to protect North Dakota's pro-life legal atmosphere. Measure 1 was drafted and passed by the legislature to protect the abortion regulations currently on the books. The current state constitution needs additional language added so that activist judges cannot interpret our Liberty Clause to have a fundamental right to abortion. Measure 1 does not create new laws or abolish old ones. It serves as a protective element, similar to a shield, against out-of-state interest groups. If Measure 1 fails, it will be nearly impossible to stop abortion groups from removing all abortion regulations, and will make it easier for physician-assisted suicide to become legal in our state. Thank you so much for watching, and please protect North Dakota laws and values by voting yes on Measure 1 on November 4th. God bless you and yours.